Hello, everybody. My name is Lita Abella. Welcome to my new show, What's Your Story in the New Normal? I'm an entrepreneur, health and wellness consultant, public speaker, licensed private investigator, and former LAPD lieutenant. And in between all of that, I went to law school and obtained my JD. I tell stories that inform, inspire, and influence others. I have a very special guest today that I'm so excited to hear about because I want to learn the information that she's going to provide us. And I think you all will be extremely excited to hear this information too. So let me introduce my guest. Her name is Lynne Boisineau. And welcome, Lynne, to my show. I'm glad you're here.
Thanks, I'm happy to be here.
And first, I just want to get to know a little bit about you. So can you tell us a little bit about your personal life?
Sure. I have 3 kids in their 20s, and up until a couple years ago, I was working in big law and decided when I had my big birthday that I was going to take a trip around the world and dive off into my own law firm so that I could spend more time at home.
Wow.
So I did that. I got some backyard chickens and built a big garden, and even long before COVID, I've been working from home. Just trying to be a digital nomad. So traveling to as many countries as I could. Obviously that's slowed way down to a stop actually. My last 7 trips were canceled, but I'm sure I'll be able to get back at it soon. So that's just
that sounds so exciting. And the reason why I'm so excited about having Lynne as my guest is because she is an attorney that specializes in intellectual property. So those of us who are content creators, I mean, just about everybody has, a website up, social media platforms, Facebook, Twitter, LinkedIn, Pinterest, Instagram. And I'm sure that we all have posted images or information, trademarks, whatever, that we probably don't even know if we really are doing the right thing. So this is why I'm so excited having Lynne on the show today. So Lynne, can you tell me, what does an intellectual property attorney do and focus on, and just kind of give us the ABCs of intellectual property?
Sure. That umbrella term encompasses a number of things, one of which is patents. And I'm not a patent lawyer, but patents have to do with inventions. So you're building a better mousetrap. It's something that's useful, it's new, it's novel and non-obvious. I don't do that area. That's more technical. So people who do that have backgrounds as engineers or scientists, that sort of thing. Then the rest of intellectual property is all the stuff I do, which I consider the fun stuff. No disrespect to patent lawyers. And the reason is because it has to do with people's brands. So that would be trademarks. Trademarks are things, like Nike or McDonald's or what have you. It's a source identifier. So it's a name that you recognize in connection with some goods or services. The other thing I do is copyrights, and copyright protects a work of art. So like the books behind me, if you do a sculpture or a painting, anything that's a work of art that's fixed in a tangible medium, meaning, it's not going to dissipate in 30 seconds, etc. That's covered by copyright. And the other thing I do is right of publicity, which is the use of someone's name, image, voice, or likeness, signature even. And that's one that trips people up quite a bit. And unlike trademarks and copyrights that are federal, right of publicity differs state by state. So it can really be a thorny issue if you haven't considered it at all. And then the last kind of couple things I do are that have to do with trademarks are domain names. So if somebody's using your trademark in a domain name, I can help get that domain name back. I can't if they're using it in a free speech way, but if they're using it in a commercial way, normally I can assist in that. And then I do a lot of talks and writing on social media, and exactly what you're saying, how to avoid all the pitfalls that nobody even knows are pitfalls and everybody thinks are okay to do, but they're not okay at all. So that's, in a nutshell, intellectual property.
Wow, that's amazing. And I'm sure that we could probably have an 8-hour class on each one of those on its own.
Yeah, at least.
Yes, yes. So not to overload all of us with so much information, let's try to focus on social media content creators, such as myself. So I threw together this show and I named it. I didn't look up to see if anybody else has a title with this name in it. I just
Don't say that.
you know, there's so many things that I guess people need to really check on to before they do something to make sure that they're doing things that are legal and appropriate and so forth. So focusing on social media and content creators, what are some of the things that we should look for?
Yeah, let's give you a best practices checklist, okay? So best practices is you're choosing the name of your show or your goods or your services, whatever they are, you should do what's called a trademark clearance search and get out there and see is somebody else using it. So even if someone else is using it, they can't necessarily co-opt that phrase or that word for everything, right? It has to be something that's confusingly similar for it to be a problem. So you're using the name for your show, somebody else is using it on toilets, somebody else is using it on like, you know, surgical services or something. None of those are going to conflict with you. But because there's only a finite number of words in the English language, and we've got microbreweries and we've got apps and we've got, you know, a million things now that we didn't have when I started doing this. We only have brick and mortar stores. We didn't even have the internet, right?
Right.
Now all these names are being used up. And if you think it's cool or it speaks to your, or alludes to your services, then probably somebody else already thought it was cool and registered it or has applied to register. And so that's really important. So there's two kinds of searches you can do. One I call the quick and dirty search, which is you go to the Patent and Trademark Office website at uspto.gov and you search to see if anybody has your trademark that you want. But you have to be careful to check things like phonetic equivalents and misspellings and that sort of thing, right? And maybe something that's a synonym for your name, but it's for the exact same goods and services, that might be a problem. So if your mark had in it Max and someone else had Magna or something like that, you know, the Latin roots are very similar, maybe that's gonna be a problem. So it's always best to have a trademark attorney do it for you. You know, somebody who's experienced and can kind of sift through the weeds, if you will. But once you pick your name and it looks like it's fine, it's a really good idea to register. You don't have to register. I'm gonna give you a great piece of advice for all your viewers. You can put the TM next to your mark, and that tells people that you're using the mark as your common law trademark. So you don't have to apply, you don't have to register, because in the United States, once you start using your mark on goods or services, you own the rights. You have senior rights as opposed to other people who come along after. And you can't use the circle R unless it's actually registered. So the TM means, hey, I'm using this as my trademark, and you're kind of telling people, but it doesn't really have legal import to it. Once you get a registration, the benefit of that is multifold. One is you're presumed to be the owner. The mark is presumed to be valid. You're presumed to have exclusive use of it. You can register with Amazon Brand Registry, which you cannot do anymore unless you have an actual registration. And you can stop infringing goods at the border by registering with Customs and Border Protection. And your mark becomes incontestable after 5 years, barring things like fraud. So it's a super powerful tool, and absolutely, I always recommend that people do that. I understand why maybe monetarily they don't want to do it. It runs about $1,000 to prepare and file the application. Most attorneys fall in that range, you know, so it's a couple $100s for the filing fee plus a couple $100 for the attorney's time. And then there's some fees down the road once the examining attorney picks up your mark. And the only reason I mention that is because some people are like, oh, we'll do a trademark application for $400. Well, that's $400 without the fees and then without the stuff that comes down line. And people, I like to manage expectations and tell people, look, it's usually about a couple $1,000s, but it's spread out over time, over about a year. It takes about a year to get your trademark registered on, you know, on the short side of it.
It does? Wow.
Yeah. Yeah.
Oh,
it's
so
not as
something you just type in, pay it, and it's a done deal.
You can type it in and pay it, but it's not approved normally until years down the road. The other thing that's important to note is that you don't have to be using it to file a trademark application. You can file what's called an intent to use trademark application and sort of hold your place in line until you're ready to use it. And you get up to 36 months after the mark is allowed. You get a notice of allowance is what it's called. You've got up to 36 months that you can pay fees, extension fees every 6 months. And then, you know, you have time to start using it. but you've already got your place in line. You've already got your early filing date. You're already ahead of other people. So that's what I always recommend. Unless, if you're going to launch in 2 weeks from now, fine, wait 2 weeks and we'll file a use-based application. So that's kind of one big thing. But let's move on to copyrights, because I don't want to get stuck in trademarks. And then nobody has any other.
Like so much.
Yeah, and I apologize. I know this is a lot of information and I talk fast, but people can contact me afterwards and get more details. So with respect to copyrights, like we talked about, it's a work of art. And so it's a sculpture, a painting, written content, etc. So what you need to be careful about, and this is super, super important, whoever does the work of art, the default is that they own it, okay? Even if you hired an artist to do it. And the reason being is a lot of people say, well, I have a contract with this designer and he's doing my logo for me, and it's a work made for hire. Okay, that's a term of art, work made for hire, and it only applies in certain situations. And you don't want to rely on that. So there's 2 ways that you would own 3 ways actually that you would own the copyright. One is the person was a full-time employee within the scope of their duties, creating that content or those photographs or things for you. Okay, so that means, like, if it's your secretary and she comes up with it, that's not really in the scope of her duties. If you have a design team, then it does count as a work made for hire. If it's the janitor, it doesn't count. Do you know what I mean? So you have to kind of, it's not automatic that just because they work for you, and maybe they're a part-time employee, that doesn't count either. The other way is if it's a work made for hire. So you have a contract in place ahead of time in writing for certain types of works of art, and they follow all the criteria for that to be a work for hire. Most things don't work that way. Most of the time it's like, oh, my neighbor did it, or my best friend, and it wasn't written down beforehand. So the best way to do it, the third way, and what I usually have my clients do, is I give them a template for an assignment. So an assignment means the person created it owns the owns the work of art, and they're assigning all of the rights over to you, including the copyright, okay? And so in order to have, the minute you paint the painting or write the content or take the photograph, there's a copyright that attaches based on the creation when it's fixed in a tangible medium. But until you've registered that copyright, you can't file with the Copyright Office, you can't get statutory damages, you can't go to federal court. You have no standing to go to federal court and fight about it. So there's a lot of reasons you would want to do that. And copyrights are so inexpensive. I think it's $65. I know they were going to be raising the fees, and I don't remember what it is yet. I haven't checked yet to see if they changed the fees, so I don't know exactly what it is. But anyway, it's under $100, okay? And it lasts like 95 years from the date of its creation. It's like 75 years plus the author's, it's like after the author's death. If it's you created it yourself and it's for you, if it's a work made for hire, it's 95 years. So it's going to last a really long time. It's a super powerful tool, and you can take down content on somebody else's social media page if it contains that work of art using the Digital Millennium Copyright Act. Okay, so a DMCA takedown is a really powerful tool, but again, you've got to have a registration. And so it's a lot of bang for your buck if you're trying to protect your stuff. And anything you put on your website, you want to make sure you own. So for example, my website has a bunch of pictures on it. Every picture on there, I took myself. And there's a reason for that. It's because I don't ever want to take a stock photo and think I have the right to use it. And the fine print says, you can use it for your personal computer and wallpaper, but you can't use it for commercial reasons, commercial purposes. And a lot of people get tripped up by that. So what happens is there's these copyright trolls that are these lawyers that all of their clients are photographers or artists of another nature. And they have web crawlers. They use web crawlers to find where somebody used that photograph. And then they ask for usually about between $20,000 and $30,000 because, yeah, because the statutory damages for a copyright registration are $750 minimum to $30,000 maximum. And if the infringement is willful, it's up to $150,000 per violation. Okay. And it costs a lot of money to fight these. And you know, and unfortunately, copyright law, it's statutory damages. So it doesn't really matter what your intent was. I mean, there is a carve out for innocent infringement, but it doesn't really usually work. It's hard to get around that. And so really what the bottom line is, you're going to pay something. And when you get that cease and desist letter, it's going to be a fight about how much you're going to pay, not whether you're going to pay. Okay.
Wow.
Because you've already done the thing. You've already done the thing that's a slam dunk. So if you had access to their copyright and you made a copy and used it, period, end of conversation, you owe money. And usually I can help people get it down to like what the licensing fee would be for that photograph for 2 years or however long it was up, or it usually goes by how many pixels it is or whatever, right? So if this artist, if this photographer normally gets, you know, 10 grand a year for a license for his picture, and it doesn't matter if it's like a picture of a bug or a leaf or a snowflake or something that isn't even, you know what I mean? It's not the Mona Lisa. It's not something that you think is super artistic. It's a picture of a piece of paper lying on the ground. You're still going to owe that, basically that 30 grand, because what's going to happen is if you don't settle it quickly and get out of it quickly, because what happens is the attorneys that take these, it's like a factory, you know, they churn out these cease and desist letters. They just do a search and replace for your name. They say, you know, my client has this, you know, attaches a copy of the registration. And then if you don't respond, or if you say like, oh, this is ridiculous, or I don't think I have to pay this, then the costs go up and up and up, because what they do is they send a second cease and desist letter, and then they file a complaint. All of these things cost money, and the attorney is making contingency like 50 to 60% of what they recover. So if they get 30 grand from you, they get 15,000. So their incentive is, you know, to run up the bill, sadly, in my experience. And you don't want that to happen.
How does a photographer, let's say it is a picture of a snowflake. I do photography, not professionally, but you know, I do it. How does a photographer prove that he or she is the person that took the picture of that snowflake versus I saying, that's my snowflake that I took that picture?
Yeah. Okay. So with the snowflake example, it's going to be super easy because every snowflake is different, right? And they took the picture, they registered with the Copyright Office, and you submit a deposit copy. So you show what you are covering with your copyright. It's at the Library of Congress. You send it in. So it's very easy to prove like who took what. Let's say something like the Washington Monument. Well, lots of people take pictures, and you could have happened to have been standing in the exact same spot that somebody else did when you took that picture. And that kind of thing, what you could do is you could show a time and date stamp on your Apple, what is it, where you download your photos, iTunes. You know, you have it downloaded on your iTunes or something like that, and there's a file and date stamp, and you can just say, no, I took this. I was on vacation in Washington, D.C. You can prove it, right? You can prove you didn't infringe their copyright. So it's not that once somebody took a picture of something, nobody has the right to take a picture of that. If I take my own picture of the Eiffel Tower, the Statue of Liberty, I'm fine. But what's happening is it's so easy to copy things off the internet, right? Mm-hmm. And people think, oh, well, I just took it from here, or I took it from the church's website, and the church wouldn't mind, or whatever. But if the church took it from somewhere else that, you know, they have a copyright registration, like it's just never okay. I mean, I tell people, like, if you're at Macaroni Grill and you draw a picture of Mickey Mouse on the tablecloth to entertain your child, technically you're a copyright infringer. You do not have the right to copy somebody else's artwork, ever.
Wow.
You just don't, if it's protected by copyright law. So because it's such a dramatic, powerful tool, it's good for you to have copyrights for your own things. And then it's you know, you just need to be mindful of what you content you put up. And what you can do is you can do a link to stuff. If you want people to see a nice picture, then say, oh, you know, there's a really great picture of blah, blah, blah. Here's the link. And then you send them there, and then they can see it on the page where it belongs. And even people who like I think it was Gigi Hadid, like even supermodels that have pictures of themselves that are taken during photo shoots, and they own their own right of publicity. They don't own the copyright. The photographer or the person who hired the photographer owns the copyright. And so certain models and actresses were putting their own pictures on their own Instagram feed, but they were violating copyright law in doing so. even though
Wow.
they own the right of publicity to them.
That's so interesting.
Yeah.
Also,
So
there are websites, like I've taken a lot of webinars and so forth, classes about, how to start a podcast and these different types of shows. And then they refer you to these free websites that have free stock photos and videos.
right.
And they tell you, oh, you don't have to pay for any of this. Everything is free because the owner has given permission to use it. So are those, if I went to a website like that, is that okay to use?
Well, it depends. So are they free for your personal use, or are they free for commercial use? You just need to read the terms on each one of those websites to determine if you can actually do what you think you can do.
Okay.
The other thing is content from 1923 and back is not covered by copyright, right? So anything older than that's why you hear classical music a lot of times in movies and this and that, because you don't need to go get the rights for those. Anything that's from 1923 and back, you can use, unless it's something from 1923 that somebody took and made what's called the derivative work. They sort of used pieces of it and turned it into something new. Then you would need to license it from the new owner, the owner of that derivative work. Yeah.
Wow.
Yeah. So then let's do right of publicity, because that's important too.
Okay.
So for right of publicity, again, you own the right to your face, voice, likeness, image, etc. And no one has the right to commercially exploit that. Like, for example, right now we have COVID-19, we have the riots, there are pictures of people taken in the news and this and that. And that's what's called the newsworthy exception, because the people who bring you the news have those people are out in public. They know they could have their picture taken, right? It's being taken by a news agency and they're reporting it in the course of their normal work, which is news reporting. If you were to take one of those photographs and use it as an advertisement for your podcast, then you would be infringing that person's right of publicity. So a famous case on that is Katherine Heigl, who was from Grey's Anatomy.
Mm-hmm.
She was shopping with her mom and happened to be coming out of Duane Reade, and you can see the Duane Reade logo on the bag. And some, just a regular random average guy had taken a picture and posted it on his social media and said, "Hey, look who I saw in my neighborhood shopping at Duane Reade, haha," or whatever, something like that. Duane Reade then grabbed the photo, put it on their Instagram, and said, "Even Katie Heigl can't resist shopping at Duane Reade." And what this did was take it from a First Amendment free speech sort of commentary to a commercial use that implies an endorsement by her of Duane Reade, which we can't have. Okay? So, and one of the most famous cases is Michael Jordan was, he was the subject of a special Sports Illustrated magazine edition of for being most valuable player. And people were supposed to write in and sort of talk about him or whatever, and you could buy advertisement in this magazine. And a Chicago grocery store chain, whose tagline was "just around the corner," had said "Hey, congratulations to Michael Jordan," and had a picture of just shoes. It didn't have his face on it or anything. It just had shoes. "Congratulations to Michael Jordan from one Chicagoan to another who's just around the corner." And he sued for the right of publicity and said, "Look, if I endorse somebody's product, it's like $5 million if it's a penny. And what you did was try to make an end run around that $5 million contract with me to endorse your stuff if that's what you wanted," right? So it's super important to remember that you can't use, and a lot of people say "Oh, but this person loved my product and, and she raves about it and tells all of her friends." Great. If you want to use her name and her picture or stuff that she said, then what you do is you get a release, a right of publicity release, and I don't care if she's your best friend, just get it. Because if you sell your company and now your company is not owned by a best friend anymore, she may not like where the direction that company goes, or maybe that company is embroiled in some kind of terrible thing. It's like the CEO is a terrible racist and something bad happens. It's I don't want to be associated with that company anymore. It's not owned by my best friend. So you have to be thinking of all these things, and you also have to think about the reason you need this express release for the right of publicity is because we can't envision what's going to happen in the future, right? None of us have a crystal ball. So someone signed, let's say, a 50-year endorsement contract in the 70s. Well, we didn't even have the internet in the 70s. We We didn't even really have computers. I mean, we
Right.
did, but they weren't in our houses. So we didn't have computers. We didn't have the internet. We didn't have smartphones. We didn't have apps. We didn't have social media. Did that person really consent in 1977 to all the uses of their name and likeness and image that we can do today? Not really. You know, so you and I need to get a fresh consent when stuff like that happens. I mean, we have holograms now, right? So when Tupac Shakur's hologram performed at Coachella, his mom owns the rights to the trademark for his name, the copyright for the lyrics to his songs, the copyright to the music to the songs, potentially, the copyright to the performance that's being projected on there, plus his right of publicity, right? So all of those are separate rights that have to be licensed individually, potentially, depending on who owns them.
Wow, that's amazing. There's just like so much you have to do.
Yeah, and sort of back to copyrights and how they intersect with social media and using music. So actually in the Tupac example, probably his record label owned the music, right? And if you set music to video images, you need what's called a master sync license. And master sync licenses are between 5 and 20 to 30 grand usually. So you should never be using music unless you have an express license from the holder of the copyright.
Wow.
Unless it's like Strauss or something, you know, it's older than 1923, and you know it for sure it's in the public domain. You can do that, which is why a lot of those Muzak sort of things are people singing somebody's song instead of the actual artist. That's because you can get what's called like a, oh gosh, it's leaving my brain right now. It's like a compulsory license. I think that's what it's called. Compulsory license for, if I'm singing a song, now I own that performance because it's my voice. I'm creating that work of art, right? And I'm making my own performance of it. And then I can just pay a compulsory license fee to the recording artist. That's different than taking their performance and using it with my images on social media.
Wow. Yeah, that's
I know
another
this is a
thing I
lot.
was going to ask you about, because that's another avenue that they direct you to, like, oh, here, go to this website because you can get all this free music, where the owners, composers of this music have given access to everybody to use it. But again, I guess you would have to look at, are you using it for personal use, or are you using it for commercial use? Read the terms under.
Exactly. And don't assume that it's in the public domain. That's a term of art. Also, people think, oh, public domain, it's, you know, I found it online. Well, that doesn't mean it's in the public domain. That's a very specific thing. Like when NASA takes pictures of, you know, space launches or things, you know, oh, the rover took these pictures or whatever. Those are in the public domain because they put them there, right? But that's not anything that's taken by a photograph taken by a news agency, anything that's in a magazine, and basically, I try to tell people, basically almost everything is covered by copyright. And it's such a crummy thing to have to fight when you get that cease and desist letter, because you're already behind the 8 ball if you had access to it and you copied it, right? And it's substantially similar. If you took it from somebody and you copied it, then it's going to slam dunk be confusingly similar, right? And so the only time something's not confusingly similar, so I don't know if this is like too deep, but so copyright protects an expression, but not an idea. So the way I distinguish that is, you know, a doll is an idea, but a Barbie doll is different from a Cabbage Patch doll, and that's different from a Bratz doll, and all, you know what I mean? So every type of doll is a different expression. Each one has its own copyright, but the idea of a doll nobody can have. And so similarly, like there was, I can't remember the author's name, but someone wrote a book called The Wind Done Gone. And it was all about, like, it was similar to, you know, Gone with the Wind, but it was written by the person who happened to be a slave who was a half sister of Scarlett O'Hara. Okay. And so it was sort of the same story, but almost like Wicked or whatever, right? Where it's like the backward story told from a different perspective, or somebody who did not experience it in the same way. And, you know, the heirs of the author to Gone with the Wind, you know, filed a lawsuit, and the court said, look, the idea of like an antebellum property where there was, you know, rich white people who lived in a house and slaves, and, you know, the Civil War in the backdrop and this and that, That's an idea. Anybody can write a story that has those things in it. They're called senza faire. Similarly, there was a video game lawsuit about Street Fighter, where they were trying to say, hey, somebody who's doing roundhouse kicks and in this kind of outfit or whatever, that belongs to us, that's part of our game. And it's like, well, no, any kung fu or fighting game has to have people doing roundhouse kicks and wearing clothes that allow you to to do this kind of martial art, right? So there's certain things that are ideas and certain things that are expressions, and only the expression part is copyrightable. But the problem is mostly everything we put on social media is an expression and not an idea, if that makes sense.
Okay. Wow, this was just amazing information. It's like I said, we could do weeks of training on this because it's just overwhelming. But yeah, we're just about out of time. So what I would like to know now is if you can give us, if somebody would like to know more information, maybe they want to hire you because all of a sudden they're looking back and going, oh my gosh, I think I need a IP attorney now because there might be some things that I'm not doing exactly the right way, or just to get information. What's your contact information, website, etc.?
Sure. So my phone number is easiest because my last name is hard to spell. And my phone number is 714-619-1594. And they can go to my website at boisineaulaw.com. And that's B as in boy, O-I, S as in Sam, I, N as in Nancy, E-A-U, law, L-A-W.com. And there they can reach me, and I'm pretty sure that my my email address, which is Lynne@Boisineau is on there as well, if it's easier to click the link. And just, what I try to do is I have like a teach a man to fish sort of mindset, right? So what I try to do is instead of trying to do everything for you, there are clients that have me do that. People I've been helping for 15 years, they have, hundreds of trademarks, and they're like, I don't want to think about it, just do everything for me. That's fine. But for people who are just starting out and they're on a lower budget and stuff, what I try to do is give them things like this assignment agreement. I'll do one for individuals that are giving them content and one for a company that's creating content. And it's a template. And so therefore you can fill it out over and over and over to get people to sign off. And, I'm leaving it in your hands to make sure that you're keeping those records. Similarly with a right of publicity release, whatever, I can give you the templates and the guidance, and then you can try to do it yourself. And on the copyright side, for example, I can make an account at the Copyright Office that's for you and save the template. And then when the next time you do something that's exactly the same, but a different picture, you can go into your own template, follow my example, and do it yourself and just pay the $65 on your credit card. So, I do try to empower people until they get to the place where they want someone to handle their portfolio or they have a portfolio to be handled, right? But in the meantime, I'm happy to help people do their own thing, right? As long as they realize the downside of doing that, which is sometimes you're not seeing issues that you could handle early. If you knew what was, if you had someone else minding the store that that's all they do, right?
Right.
But I obviously I can help people out of hot water later on too. I prefer to give them best practices and give them all the tools they need so they can go forward without having to deal with that kind of stuff.
Right. Well, this has been just amazing and very, very educational information on all these different subjects under the IP umbrella, intellectual property umbrella. So I want to thank you so much for your time, and I know your time is very valuable. So I'm going to go ahead and thank my guest, Lynne Boisineau, and until our next episode, which would be in another week, I hope everyone stays healthy and stays safe. And I know right now the world's a little crazy, but hopefully we'll all get through this. So thank you very much.
Thanks for having me. Bye.
Thank you. Bye.